Peace, peace, peace. Welcome to the Universal Temple for the Sun and Stars. I'll be your host, Lord Messiah, and we're gonna go back into international law. We're gonna jump straight into it. Um, so you know what I mean. We're gonna go into this. I'm gonna read off of this breakdown, and then we're gonna go. I'm gonna just or rather I say, I'm gonna let this read out, and then I'm gonna break it down. Rather I say. All right. And this is dealing with international law. So like I said, I'm gonna let this play out, and then I'm gonna break this down. All right. So yeah,
7. International law. The court is the organ of international law. The court, principal judicial organ of the United Nations.
and they're talking about the when they talk about the ICJ, the International Court of Justice. This is the court they're talking about. So basically, they're talking about the International Court of Justice and how it implements international law.
Nations.
And understand that international law is basically just international case law. You know what I mean? Because it's all based upon previous laws that were passed, or previous cases that were decisions of previous cases. You know what I mean?
Nations has described itself as the organ of international law. It dispenses justice within the limits that have been assigned to it by its statute. There is today no other judicial organ in the world which has the same capacity to examine legal questions concerning the international community as a whole, and which offers states so wide a range of opportunities for promoting the rule of law. It is thus the only international court with both general and universal jurisdiction. The disputes that have come before the court have covered the most varied aspects of public and private law, have concerned all parts of the globe, and have necessitated an examination of multiple legal systems and of wide-ranging state practice. The court has also been called upon to address a number of questions relating to the law of international organizations. Irrespective of the nature of the issues brought before it, the court has contributed to their resolution, and thus to the maintenance of peace and to the development of friendly relations between states. The court applies international law. Article 38, paragraph 1 of the statute of the court declares that the court's function is to decide in accordance with international law such disputes as are submitted to it. In every case, after determining which rules of international law are applicable, it is the court's duty to give its decision based on those rules. Article 38, paragraph 1 goes on to provide that the international law to be applied by the court is to be derived from the following sources. A. International conventions, whether general or particular, establishing rules expressly recognized by the contesting states.
Right, which are basically the treaties between nations. So they will make decisions based upon the provisions expressed in the treaties between the nations.
States.
And by states, they're saying
as evident.
By states, they're saying nations. They mean nations. You know what I mean? So international customs as evidence of general practice accepted as law. So in other words, like in certain Islamic countries, well, not certain, in Islamic countries, their customs are based upon the Quran, you know what I'm saying? And the customs and so forth coming from the Quran and their cultural identity and beliefs and so forth. So that's what's generally practiced and accepted as law. You know what I'm saying? Like, so in other words, the practices of the people are so, internationally customary that they are generally practiced and accepted as law. So they also, customary law is a very big part of international law because international law respects the customs of other nations.
Evidence of a general practice accepted as law. C. The general principles of law recognized by civilized nations.
Right.
95.
So, for example, like I said, the general principles of laws recognized by civilized nations. So, in some nations, they may say, "Well, yo, you know, I don't know if it's so strict like that, to this day." But in some countries, man, like, yo, if you steal something, you get your hand chopped off. That's the law. So, what I'm saying? I don't think anybody trying to steal anything in those kind of countries, you know what I'm saying? So it's like, but now in the US, they may consider that to be uncivilized. Like, yo, we ain't gonna chop somebody's hand off. We might put him in jail or something, but we ain't gonna chop your hand off, like, you know what I'm saying, type thing. So they may consider that to be uncivilized. So there may not be a practice here in the US, and they may not treaty with another nation that deals in that type of custom, because if an American or so-called US citizen goes over there to that country, and they are subject to the customs of that country, then they may, experience something like that. And that's not, I don't think they want to do that. So anyway, it's the general principles of laws recognized by civilized nations.
INT Handbook 2019.
And I'm not saying that practice was uncivilized, but I'm just saying,
2019.qxp_mice and page 1 June 11th. 2019, 935. D. Subject to the provisions of Article 59, judicial decisions, and the teachings of the most highly qualified publicists of the various nations, as subsidiary means for the determination of rules of law.
That's what I was explaining earlier about your publication. When you make because it's your responsibility to make your information publicly known, but also when you're dealing with the Secretary General and the Department of Legal Affairs, they also make these information known to the nations that wish to accede to your treaties. But it will be your responsibility to make your international publication of the rules of the Constitution for your nation, or whatever the case may be, whatever your teachings or philosophy or whatever the case may be, make all that publicly known, you know what I mean? And when it says they respect the most highly qualified publicists of various nations, so there will be like a publicist of your nation, or one who has the archive or the records of all your national publications, and they will be able to express these things and as a subsidiary means for determining the rules of law. So, you would have a representative of your nation make that knowledge born. And, that will be the basis of determining, the rules of law. And also, I was expressing also how that's how, when you draw up your constitution and you declare your jurisdiction, things of that nature, you actually create your own law for your nation. And as long as it's generally, in cohesion with the, as they say, the generally accepted rules of, the civilized nations and so forth, then most likely it'll be respected.
Law. The above is not an exhaustive statement of the foundations on which the court can construct its decision. Some are listed, but not all. For instance, the paragraph does not mention unilateral acts of states, nor does it make reference to the decisions and resolutions of international organs, which very often contribute to the development of international law and may also be sources of rights and obligations.
Right. So in other words, you might have other certain, declarations of human rights and stuff like that. It's not necessarily dependent upon that unless both parties agree to make that the said statute of law, that they both agree upon. Then it could be brought forth, into the law. So that's another thing too. The parties actually have a determination in the law too, because it's based upon what they accept as the law, to be brought before the court. So that's another good thing too, you know what I mean?
Whether the court is
because the science is that's what's the science of international law. You're dealing with different laws of different nations, and then when they come before an international court, the court has to consider the laws of each of both nations and see whether, if they were in treaty with each other, whether one side has or both sides have breached the treaty, or if according to their own treaties, if they are in breach of that, you know what I'm saying, to in harm of any other nation, you know what I'm saying, whatever the case may be. So it's based upon the treaties, and they're about to get into the next chapter, treaties and conventions.
Deciding a case of a contentious nature, or is engaged in advisory proceedings, it applies the same sources of international law, and its decisions hold the same high level of authority, since, in both instances, it is laying down the law, even though the consequences of a particular decision may be different. It is only with the consent of the parties that the court is authorized to move away from the sources listed in Article 38, paragraph 1 of the statute, and rule according to what is reasonable and fair, ex equo et bono, see below, p. 98. Treaties and conventions. The expression international conventions in Article 38, paragraph 1, is a broad one, covering not only bilateral and multilateral treaties and conventions formally so called, but also all other international understandings and agreements, even of an informal nature, provided that they establish rules recognized and accepted by the states parties to the dispute. The ICJ has emphasized that manifest acceptance, or recognition, by a state of a convention is necessary before the convention can be applied to that state. It often happens, however, that the language of a treaty or international agreement, which is relied on before the ICJ as containing rules recognized by the states parties to the dispute, is not so plain and precise as to make it clear that such treaty or agreement is applicable to the circumstances of the case in question. As the decisions of the court show, it will then be for the court to interpret the instrument and to determine its scope and effect with a view to applying it. In practice, it falls to the court to interpret a treaty or agree meant in at least 3 cases out of 4. In doing so, it seeks in the first place to determine the ordinary meaning of the words in their context, in light of the object and purpose of the instrument in question, without, however, sticking too closely to the particular rules applicable under the procedural law of any legal system. In that regard, it frequently refers to Article 31 of the 1969 Vienna Convention on the Law of Treaties, which it has recognized as having customary scope. In its advisory opinion on the legal consequences for states of the continued presence of South Africa in Namibia, the court stated that an international instrument has to be interpreted and applied within the framework of the entire legal system prevailing at the time of the interpretation. 96. The International Court of Justice, Handbook. INT Handbook 2019.QXP_MICE, page 1, June 11, 2019, 935, page 96. Custom. The court's practice shows that a state, which relies on an alleged international custom practiced by states must, generally speaking, demonstrate the court's satisfaction that this custom has become so established as to be legally binding on the other party.
All right, so part of stuff. Let me go back up here because I was running in there to get my food real fast. Hold on, babe. I'm talking to you a minute. I'm doing my live. Hold on. So it says the expression international convention and yeah. So basically what they were saying was here is that basically, you know, they had the conventions, you know what I'm saying, to declare the treaties and so forth. And then after that, you know what I'm saying, everything will be interpreted, you know what I'm saying, based upon the treaties, you know what I'm saying. So now they get into customs, and they just lesson. They said satisfaction, which demonstrate to the court satisfaction that this custom has been so established as to be legally binding on the other party. So in other words, if we say, yo, we the gods of earth, you know what I'm saying, we wear our crowns, you know what I'm saying, we greet in peace, we speak in the language of supreme mathematics, we've been doing all these things for many years, many customs. When we throw up our 2 fingers, that means a symbol of peace. It's not any type of sign of disrespect or something like that. So when we go like that, that's what that means. It means peace. You know what I mean? Stuff like that. Like these are all customs. You know what I mean? So this is something that could be respected as, saying, and legally binding on any other party if they were to disrespect our customs. You know what I'm saying? Because you know how, like, saying the Jews always was trying to say everything is all anti-Semitic, anything they find offensive. Oh, you're being anti-Semitic. You're being anti-Semitic. Yeah. So if we feel that somebody's being discriminatory toward us, then we can say they're being anti God, anti, anti 5%. You against the 5% or whatever. You know what I'm saying? You got something against me because I'm a 5%er. You know what I'm saying? When you're on your job and your boss treat you some kind of way differently because you wear your crown on your job and, you express your culture and you make it known who you are. And they hate on you because of that. That's discrimination. You know what I'm saying? So, stuff like that. So let's continue.
Party. In the North Sea continental shelf cases, the ICJ stated, with respect to customary international law, not only must the acts concerned amount to a settled practice, but they must also be such, or be carried out in such a way, as to be evidence of a belief that this practice is rendered obligatory by the existence of a rule of law requiring it. Similarly, in the case concerning the continental shelf, Libyan Arab Jamahiriya/Malta, it recalled that the material of customary international law is to be looked for primarily in the actual practice and opinio juris of states. In the case concerning military and paramilitary activities in and against Nicaragua, the court found that while it could not deal with complaints based on certain multilateral treaties owing to a reservation accompanying the declaration recognizing the compulsory jurisdiction of the court, that reservation did not prevent it from applying the corresponding principles of customary international law. It explained that the fact that these principles have been codified or embodied in multilateral conventions does not mean they cease to exist and to apply as principles of customary law, even as regards countries that are parties to such conventions. Furthermore, such principles continue to be binding as part of customary international law, despite the operation of provisions of conventional law in which they have been incorporated. Judicial decisions. Judicial decisions and the teachings of publicists do not have the same status as other sources of law. They merely constitute a subsidiary means for the determination of rules of law. Judicial decisions are subject to the provisions of Article 59 of the statute, which stipulates that a decision of the court has no binding force except between the parties, and in respect of that particular case, see above pages 77 to 78. Nevertheless, both the ICJ and the PCIJ have made frequent reference to their own jurisprudence in the reasoning of their decisions. Moreover, the ICJ often cites its predecessor. The court also sometimes cites decisions of other international courts and tribunals. In the case concerning application of the Convention on the Prevention and Punishment of the Crime of Genocide, Bosnia and Herzegovina. 97. International Law. INT Handbook 2019.QXP_mice and page 1 June 11, 2019, 935 page 97. INA v. Serbia and Montenegro, the court accepted as highly persuasive relevant findings of fact made by the International Criminal Tribunal for the former Yugoslavia, ICTY, at trial, and found that any evaluation by the tribunal as to the existence of the required criminal intent was also entitled to due weight. It cited a number of decisions of the ICTY in its judgment. The court has also referred on a number of occasions to decisions of the International Tribunal for the Law of the Sea, example, territorial and maritime dispute, Nicaragua v. Colombia, as well as to decisions of various arbitral tribunals, see, for example, maritime delimitation in the area between Greenland and Jan Mayen, Gabsakova-Najamaros Project, Kasakili/Cedodo Island, maritime delimitation, and territorial
questions. All right. So basically, that was dealing with customary law. So basically, I think they were saying in there how they was explaining also how basically it's not just based on the what's in the treaties, but also if countries have or nations have certain customary laws that they hold near and dear to them, just as a custom of their land or their jurisdiction and so forth. then that is to be respected as well, you know what I'm saying, beyond whatever treaty or so forth they may have entered into. That's why you have what's called an instrument of full powers. Your instrument of full powers that you sign before you accede to a treaty or so forth is kind of like stating that it's kind of like you're stating your what they call preliminary or plenitentiary area, something like that, rights. The rights that exist before you even go into contract, basically stating. Like, you know what I'm saying? Like you're not relinquishing any of your, natural rights or inalienable rights and so forth. Excuse me. Before you go into any contract or treaty or so forth. You know what I mean? So that's basically what that's stating.
Widespread state practice in a particular area. Thus, in the case concerning jurisdictional immunities of the state, the court examined the domestic jurisprudence of various states in order to establish state practice concerning the immunity of the state in respect of the acts of its armed forces. Ex equo et bono.
So in other words, the act of its armed forces. See, so when they say armed forces, they also talk about nations, not just like states. You know what I mean? But if you're dealing with states, you know what I'm saying, in their so-called law enforcement, in different states, they got different laws. So the so-called law enforcement can enforce different things, you know what I'm saying, based upon the laws. Now this next thing is ex apo et bono. And you're gonna break that down.
Bono. Paragraph 2 of Article 38 of the statute provides that paragraph 1 of that article shall not prejudice the power of the court to decide a case ex equo et bono, if the parties agree thereto. Although this provision has never been applied, it calls for comment.
All the stuff it says, although the provisions have never been applied, it calls for. Part of stuff it says, shall not prejudice the power of the court to decide a case X, however you pronounce that, if the parties agree thereon too. So in other words, like that's why they talk about, if the both parties give the court the jurisdiction to make its decision, then it'll make its decision. You know what I'm saying? Which is the same thing in regular courts too, but we be so scared and we think like they're the law and we have to submit to the courts and we have to like, nah, man, you got a little bit of power, like, you know what I'm saying? Flex that muscle a little something. But anyway.
Comment. Its effect is to allow the court, in the specified circumstances, to settle a dispute without strict regard for the existing rules of international law, but according to what is fair and just.
Right.
Absent the consent of the parties to the case, the court cannot follow this course, but must apply the law, in accordance with the provisions of paragraph 1 of Article 38. The decision of a case ex equo et bono must be distinguished from cases where the court applies the general principles of law recognized by states, or the equitable principles of international law, or interprets existing law in an equitable manner, equity infra legem. In 98. The International Court of Justice, Handbook. INT Handbook 2019.QXP_mice and page 1 June 11th, 2019, 935, page 98.
Yeah, so you know what I mean? I ain't gonna go through the whole thing. But basically, they're breaking down a lot of science with that, you know what I mean? And I don't know if it's still maybe it's going now. But I had it highlighted earlier. I don't know if it was still highlighted. But this paragraph I was breaking down what he was talking about sovereignty and how basically you have to declare, like this right here. I'm gonna just go through this very briefly. It says, in regards more generally to territorial sovereignty, the court has enshrined the principle to the intangibility of frontier inherited from the decolonization, and as well as the ut possit juris, whereby the legal title enjoys priority over the effective possession as the basis of sovereignty. So in other words, You can physically occupy a land, but if you don't have any legal title or claim to the land, the legal title will have more of a priority than your effective possession of the land. So like I was talking about the school, and we have an adverse possession claim on the land, we can physically be their possession, but if somebody got a legal title, or someone puts a legal contract in place to go in place the day after that 100-year contract is up, then guess what? They're going to hold legal precedence. And just because we're physically there, they can have us moved off the land. So that's why I say we need to bring the school into a trust and into a will, so that way we have an even more secure on the assets, which is the land and the school itself. You know what I'm saying? And we could do that for all the schools, you know what I'm saying? In all the different regions of our national jurisdiction. See how we got to start thinking, you know, say all the different schools in the different regions, you know what I'm saying? We have to look at that as a jurisdiction that we're building. You know what I'm saying? We have an extensive jurisdiction, an empire that is expanding. That's how we got to start thinking on a national level, you know what I'm saying? So, you know, like I said, we got to have some more paperwork to have a more secure claim. It says possession. Now, it says possession being decisive only in the absence of such title. So, in other words, decisive meaning like, you know, there's going to be a decision made, you know what I'm saying? And it could go either way in absence of a title, you know what I'm saying? So, in other words, possession being decisive only in the absence of the title. So in other words, if we had title, a proper title, more than just an adverse possession claim, but we had a more proper title for the extension of the possession of that land, then there's nobody that could come in and try to say anything da. So we got to understand contract law, you know what I'm saying? However, possession being decisive only in absence of such titles. So like I said, we got to have a title, and if we're in absence of a title, then possession will be decided, you know what I'm saying? And not by us. It will be decided by the state that'll come forth and do whatever. Land and maritime boundary, you know what I'm saying? But this is between Cameroon and Nigeria, and then they go into the Soviet over the Palua and territorial and maritime dispute. So that was a case dealing with a maritime dispute, as to where I guess there was some absence of title, and a person's legal title enjoyed the priority over the effective possession as a basis of sovereignty. You know what I'm saying? And the possession was decided in absence of a title. So therefore, we have to have a title. We have to have a title. In the area of decolonization, the court had occasional to stress the primordial role of the principle of self-determination viewed as an ongoing process. So in other words, the court said, well, since no one's taking this land, we say that we're just going to do it and we're going to take over. You know what I'm saying? So then they just drew it up, their documents, and just took over. And since nobody said anything, then it was what it was. So somebody got to come with a counterclaim. Somebody got to come in, you know what I mean? The court recognized that the right of the people to self-determination, as it has evolved from the chapter from the United Nations practice, has an erga omni character, and that the corresponding principle is one of essential principles of contemporary international law. So in other words, it's contemporary international law. So basically, based upon the laws that exist right now, they're allowed to do what they do. So until somebody come along and change up the law or create a new contract or make a counterclaim or do anything like that, it is going to be what it is. You know what I'm saying? Because nobody's coming forth and doing anything. People are content with being a nation within a nation and waiting for that nation that they're within to do something. No, you got to come out of her, as the scripture says, come out of Babylon, as they say, come out of the matrix, and then stand on your own. And then you take seat to make the new international treaty. As I'm suggesting, we as the nation can draw up a universal treaty of peace. Like I said, we're the one presenting the treaty. So therefore, people are acquiescing to our provisions and what we are saying. You know what I'm saying? So people keep talking this, oh, well, we begging a white man for something, or we asking him, or we did. No, 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 no. You draw up your own treaty and have people accede to it. So anyway, this goes right here. It says it goes into the Law of Treaties. Let's read from here.
Tory. The Law of Treaties is one of the many other fields in which the court's continuing awareness of developing legal trends has found expression. As early as 1951, after referring to the traditional views concerning the validity of reservations to multilateral treaties, the court noted the emergence of new trends constituting a manifestation of a new need for flexibility in the operation of multilateral conventions, reservations to the Convention on the Prevention and Punishment of the Crime of Genocide. The ICJ has also rejected rigid approaches to the Inter. 102. The INT Handbook 2019.QXP_MICE page 1. Treatation of Treaties. As mentioned above, P96, it has emphasized that an international instrument has to be interpreted and applied within the framework of the entire legal system prevailing at the time of the interpretation. Indeed, well before.
Also, have you heard that? It says, as mentioned, it emphasizes that an international instrument, such as a universal treaty of peace, has to be interpreted and implied within the framework of an entire legal system prevailing at the time of the interpretation. So in other words, if you trying to come to the International Court of Justice for any type of, you know, saying there has to be some type of international instrument, some type of constitution, some type of bylaw, some type of treaty or declaration that's been presented that they're standing upon. You know what I mean? So indeed as well. And as far as the entry into force, when they talk about the entry into force of the Vienna Convention of the law on the laws of treaties. So for example, like that's where the World Court, all of this stuff they talk about, United Nations, all of that, all of this stuff goes back to the Vienna Conference. And this was like the World Conference or the Vienna Convention, the Vienna Convention. This was like a world convention that they had dealing with the law of treaties, where they establish all these rules and laws and provisions and so forth and put all this stuff into play and said, oh, in all these nations around the world, they said, okay, we all agree to this. And then they put it in play, and then they started to rule off of this. They started to, do everything off of this and, conduct their ways. So now when you're dealing with the International Court of Justice, they're all aware of all of this, and all of this comes into play. You know what I'm saying? So, yeah,
Before the entry into force of the Vienna Convention on the Law of Treaties, the court unhesitatingly described it as an instrument which, in many respects, represented a codification of customary law. For example, in the fisheries jurisdiction cases, jurisdiction phase, with respect to Article 62 of the Vienna Convention concerning a fundamental change of circumstances. More recently, in the Gabsakova-Najamaros project, the court reaffirmed that the rules codified in Articles 60 to 62 of the Vienna Convention are customary in nature. On many occasions, the ICJ, like its predecessor the PCIJ, has contributed to the definition of the principles governing state responsibility by establishing the conditions and consequences of the engagement of state responsibility. The court has frequently been called upon to determine the imputability of a wrongful act to a state, United States diplomatic and consular staff in Tehran, military and paramilitary activities in and against Nicaragua, armed activities on the territory of the Congo, Democratic Republic of the Congo v. Uganda, application of the Convention on the Prevention and Punishment of the Crime of Genocide, Bosnia and Herzegovina v. Serbia and Montenegro.
And the enslavement of so-called African Americans in the United States for over 400 years.
Montenegro. The court has also been called upon to rule on various other issues concerning state responsibility, including a state of necessity as a ground for precluding the wrongfulness of an act, legal consequences of the construction of a wall in the occupied Palestinian territory, Gabsikovo-Najmaros project.
All right.
P. Post two branches of international law obviously have a scope that is distinct. A determination of whether a convention is or is not in force, and whether it has or has not been properly suspended or denounced, is to be made pursuant to the Law of Treaties.
Right.
On the other hand,
oh, hold on, what? Say that again. A determination of whether a convention is or not in force, or whether it has been properly suspended or denounced, is to be made pursuant to the law of treaties. So in other words, when you present a treaty, you're going to have a convention, you know what I'm saying? You're going to have a sit down and have a convention, and you're going to treaty with other nations that wish to accede to your treaty. You know what I'm saying? Because once you present this treaty, other nations are going to be like, oh, word, there's a new treaty on deck. Other nations going to start looking at it. You know what I'm saying? Like, oh, okay, yo, that sounds peace. You know what I'm saying? Yo, you know what? I would like to deal with that. I would like to treaty with them. You know what I'm saying? Okay, you know what I'm saying? That treaty sounds official. All right, no doubt. And then they treaty with it, and now you have alliances. You know what I'm saying? You got alliances now. You got brothers across seas. You got not even necessarily across seas, because international just don't mean across seas, but I'm just saying, you know, in general. You know, you would have brothers over here. You have alliances. You create alliances. That's what it's about. Building. You know what I'm saying? Because we think we're so sufficient on our own. We ain't got no military. We don't have a national gross product. We don't have, there's a whole lot of stuff, man, that we know we don't have, that many other nations have. So, like, you know, and that's not to down talk the nation, man. I'm just trying to tell you, man, we have to upgrade. We have to upgrade, because all this content stuff, because I'm tired of brothers when I be presenting this stuff to brothers, and maybe, and, you know, subconsciously I get it. You know what I'm saying? Maybe a lot of times when I'm coming and I'm dropping all this information and some brothers, it might be a little overwhelming. They may not want to say that, but it might be a little overwhelming. You know what? I keep it, this brother I was building with at the Parliament the other day, he kept it real, because he said, you know, God, I'm gonna check this stuff out, and I'm gonna start reading up on before I build with you, though, because actually, you know, I ain't there where you at, you know, so I can't really express it the way you add it. You know, so, and I respect that to the fullest. That was so real and so true. And he being older than me said that and expressed that. He wasn't jealous. He wasn't a hater. He wasn't feeling some kind of way about himself, like he didn't know something that he should know. He admitted the fact, like, yo, bro, I'm not as in depth with it as you. I'm not as, you know, well versed with it as you. But listen, I'm gonna study up on everything you showing me. Boom, 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 and I'm gonna get back with you. That's what I'm talking about. You know what I'm saying? That's what I'm talking about. Not feeling like some kind of way, like, oh, well, who's this young man trying to tell me all this stuff, and I gotta listen to him, and I don't feel like I'm in class or something. Man, I'm a grown ass man. I ain't gotta listen. No. He put his ego. If obviously he wasn't dealing with ego, but if he was, if he happened to be, he put it to the side and admitted the truth and dealt with the truth. So that type of person I can build with, and we can actually get stuff done. Because now after he does his research and he, you know, gets up to the point where he feels he needs to be, then we could kick it and we could go through this stuff and we could get some more stuff done. You know what I mean? And that's how it goes. You know what I mean? It ain't about you feeling like, well, it'll take me a long time to get where you at and all that. Like, nah, man, everybody works at their own pace. And like the brother said himself, he said he's gonna study, he's gonna get up on it, and once he get up on what he needs to feel he need to get up on, he gonna get back with me. So like, that's what's up. You know what I mean? And so it ain't about, like, you know. Anyway. So what I was saying is that, like, a determination has to be made. You have to have a convention and stuff like that. Like, that's how the civilized world does things. You know what I'm saying? You know, and like I said, you know, people be making statements as if, like, you know, you can just make some kind of announcement or just go about your way of being and act like you so free and sovereign, and not make no declaration to the world and not make anybody on notice about anything and But I'm like saying, like, now, if we weren't considered 3/5 of a human being by the Constitution, and if we weren't bound to the state, if we didn't have birth certificates, social security numbers, state IDs, and the cops didn't have the ability to just pull you over and ask you for ID and then treat you any kind of way, because once you give them that ID, that is making you state property, and then him as a custodian of the state's property, he will treat you like he's your parent and tell you what to do and direct you. And if you disobey any of his orders, he can lock you up and take you to a prison and restrict you of your freedom. That's fucking slavery, man. Like, I don't care how we want to dress it up, and just because we allowed to walk around and act all free and you allowed to have a job and all this and da-da-da, man, this shit is still fucking slavery, man. You know what I'm saying? So I don't want to hear all that shit, man. So if we weren't in that condition, then we could say, oh yeah, we free, we sovereign, and all of that type of stuff. But born universal truth, if we're in that status, in that state and condition, then we can't really be saying that we are all that, you know what I'm saying? And like I said, man, it sounds tough and it sounds mighty and it sounds all, you know, tough when you say it and all of that, but that's not the reality. You know what I'm saying? I'm dealing in reality. And you know what I'm saying? Like I said, just dealing with understanding the laws. And I'm not saying, like I said, once again, understand this too. All of this law stuff ain't saying like all this law stuff is going to change the attitude of whatever. But it will put you in another status, and it will allow you to then, after you get in a certain status, to dress yourself and carry yourself in a certain uniformity that will now have to be internationally not only respected, but also protected. Because there's international protections for or rather I say what's called internationally protected persons. You know what I'm saying? Look up 18 US Code 112. I ain't even gonna go into it right now because I did it in many other videos. I'm giving you the chance to look it up. 18 US Code 112. Internationally protected persons. Look that up and see what that says. And see what happens when you get into that type of status and how you're protected by international law. You know what I mean? If anybody makes any threats towards you, threatens to make any type of violence towards you, that's a $5,000 fine, a $10,000 fine, possible 5-year imprisonment. You see what I'm saying? 3 to 5 year imprisonment or something like that. You know what I mean? You can read the statute and see what it say. Yeah, I mean, like stuff like that. So that's why these other people that are walking around with all these international customary law protections and so forth, and you can't say certain things to them because they'll call it anti this and anti that. That's because they're protected by international law. You be like, what makes them so special, man? I could have said the same thing to this person and they ain't say nothing and they ain't da-da-da, but I said it to this person and all of a sudden it's a big old this and that. It's a hate crime. It's a this and that. It's an anti this and anti. You know what I'm saying? Because they're protected by international laws. You know what I'm saying? That's why. And you're subject to state laws. See what I'm saying? You see the difference? It's a big difference. So all this, we're sovereign. How you subject to state laws and then sovereign at the same time? That doesn't, you can't be a, you know what I mean? So anyway, and evaluation. All right, let me finish. Yeah, I'm gonna finish this up too.
And an evaluation of the extent to which the suspension or denunciation of a convent tie-in, seen as incompatible with the law of treaties, involves the responsibility of the state, which proceeded to it, is to be made under the law of state responsibility.
Yeah, so in other words, if something happens beyond the treaty or whatever, then the state got to deal with that, you know what I'm saying, or whatever, blah, 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 blah. So listen, like I said, I ain't going to go through all of this all night or whatever. I just wanted to give y'all some more info, some more knowledge and understanding on international law, you know what I mean? And this has been another universal nation, or rather I say universal temple for the sun, planet, moon, and stars. Lord Messiah Law L Nation production. And yeah, you know what I mean? I'm gonna see y'all in the next session. Peace to the fam. Y'all have a good night. Love y'all. Peace.